Good afternoon and welcome to Hub's 2025 Compliance and Benefits Update webinar. Thank you so much for taking the time to join us this afternoon. During today's presentation, we'll dive into key regulatory changes affecting employee benefits compliance in the coming year. Before we get started with today's topics, let's review a few housekeeping items. This session will be recorded. An email will be sent to everybody registered containing a link to the recording as well as a copy of the presentation materials. Feel free to submit questions or comments during the presentation. You can do so in the questions section found in the upper left-hand corner of your screen. Time permitting, we will address any questions that we can at the end of today's presentation. Lastly, after the webinar ends, you will see a survey pop up before exiting. If you're able to do so, please take a minute to fill it out and provide us with your feedback. This is very helpful to us as we plan for future topics and events. All right, so let's do introductions. My name is Kevin Brady, and I'm joined today by my colleagues in compliance, Sonia Gordon and Russell Denver. We made sure to cover as much as territory as possible for this one, seeing as Russell's in Massachusetts, I'm in Chicago, and Sonia is all the way out in California. So we're really talking about coast-to-coast representation. All right, so we've got a lot to talk through today and a number of important topics to go over, so let's jump right into it. All right, so we'll start with a quick overview of fiduciary duties, focusing on the current landscape and offering some best practices. We'll then jump to transparency and reporting, where we'll talk through both ongoing requirements and potential legislation that could be coming down the pike. We'll spend some time talking about the ever-relevant Affordable Care Act, reporting requirements, the employer mandate, and some recent updates as well. And then finally, we'll end with a broad overview of some significant benefit updates, and we'll talk about the shifting regulatory landscape under the new administration, a topic sure to be top of mind for many of us. All right, so first topic, fiduciary duties. Fiduciary duties are not a new concept. In fact, the standards that we adhere to today were first outlined in the Meinhard v. Salmon case way back in 1928. In general, fiduciary is subject to standards of conduct and behavior with enhanced duties of care and integrity, basically because they act on behalf of another person or entity. So for our purposes, under ERISA, plan sponsors of both retirement and health and welfare plans are bound by those fiduciary standards when it comes to the administration of those plans. At a high level, fiduciaries are bound by the duty of undivided loyalty, exclusive purpose, so acting in the exclusive purpose for providing benefits, of the exclusive purpose of providing participants with benefits and paying reasonable plan expenses. And then the duty to be prudent is another important one. So acting with care, skill, prudence, and diligence when it comes to making plan decisions with plan assets. So why are we talking about this now? Well, we've seen a number of lawsuits, initially in the retirement space, but more recently in the health and welfare space as well, alleging breaches of fiduciary duties. So this is really coming up in a big way. And this is really going to be relevant for large self-funded employers, but it's also something that really all plan sponsors should be aware of, right? In addition to high-profile cases hitting the newswire, we've also had some, regulations, guidance issued by the DOL that has really focused on fiduciary obligations as well. So talking about cybersecurity, and as we'll discuss later on, mental health parity. Some of those regulations also include some fiduciary aspects to those as well. Importantly, just something to note is that when it comes to these cases, fiduciaries have both personal and fiduciary liability. So not only is the plan sponsor potentially on the hook for a potential breach of those duties, but HR executives, benefits committees, they may be liable as well. That really kind of highlights the importance of fiduciary liability insurance as well, which is something that we'll talk about in just a moment. So let's take a look at a couple of the big cases that have hit the newswire. Again, these are going to be large employers with self-funded plans, so it's highly relevant for them. Again, all plan sponsors should really be considerate of fiduciary obligations and acting in the best interest of the plan. But just to talk through a couple of these cases in a little bit more detail, one of the biggest ones in terms of notoriety, or I guess notoriety being the best way to describe it, would be the case against J&J. In here, there's been allegations that J&J failed to monitor and manage their PBM costs. The argument being that the plan didn't prudently monitor that vendor, and they ultimately allowed them to charge excessive fees over time. So at the end of the day, breach of fiduciary duty, the duty to be prudent, right? Important to note on this case that as of the end of January, there was a dismissal of 2 out of 3 of those claims, but those claims were dismissed without prejudice. So via legal parlance here, essentially they could be back on the table if those claims are remedied, just like filing differently or anything like that. So it's totally possible that those come right back onto the table. We could still see some action there, but there is still an existing claim even if those two kind of go away. So it'll be interesting to see how that one plays out. Another interesting case is with Lockheed Martin, again, another large employer. And here we talk about, or the case talks or alleges that the company mismanaged plan assets and that ultimately impacted plan participants by leading to higher costs for them. So aside from J&J and Lockheed, we've got two more relevant cases here involving Wells Fargo and Kraft Heinz. Again, all big employers, and I think that kind of ups the notoriety, right, when it comes to publication and everything like that. But interesting note here would be on the Kraft Heinz case. And here, Kraft Heinz, as the fiduciary, has actually brought suit against their vendor, alleging that the vendor has illegally withheld information regarding certain payments that they've made to providers. The argument being that since they won't provide that data, Kraft Heinz can't reasonably assess and monitor their handling of their plan funds, right? So at the end of the day, Kraft Heinz has a fiduciary obligation to their plan participants. Part of that is to monitor their vendors, and they're not being allowed to do that. Therefore, their fiduciary obligations have been compromised. So this is really a proactive step made by Kraft Heinz to say, hey, you're standing in the way of us fulfilling our obligations. We could be found liable if there's a breach of our duty here. So it's a very proactive step on their end, and it really is, I would guess, like it's a step above, but it does really represent the level of care and duties involved for fiduciary. So it is an interesting case, and I'll be interested in the outcome there too. So anyway, given the increased scrutiny and focus on the plaintiff's bar, plan sponsors of all sizes should be mindful of their fiduciary obligations and take proactive steps to ensure that they are in a good position to uphold those duties. So what are some best practices to go over here? So the first one deals with due diligence, right? So thinking about due diligence of either the selection of new vendors or the monitoring of existing vendors. And really this has to do with the duty of being prudent, so making a prudent decision when it comes to the selection of vendors. And what's really interesting about the duty of prudence is really it doesn't talk about, or it doesn't really consider the result, it more considers the process that went into making that informed decision. So a lot of times we can be very results focused, but at the end of the day, did the plan sponsor, did the fiduciaries make an informed decision when they went through that process, right? So focusing on the diligence process here. So really there's two big contexts in which this would come up. Number one would be the selection of new vendors, and number two would be the monitoring of existing service providers. So when it comes to selecting new vendors, just make sure that there's a process in place to compare services, pricing, and contract terms, so that again you can make that prudent, informed decision on any new service providers that you might be hoping to engage. So wait, what does that look like, right? Just maybe don't sign up for just the first provider that you engage. Take a look at a few different options. That way you have like a full picture of what the market might provide. And again, this doesn't necessarily mean always going with the lowest cost provider. If the lowest cost provider doesn't provide the same level of service and other aspects that might be important to you as the plan sponsor, there's no requirement here to go with the lowest cost. More that you're making an informed decision and that you're doing it in the best interest of the plan participants, right? Moving beyond to existing providers, so these are obviously providers, service providers that you're already working with. You're not going out to a new selection, but you also have a duty to monitor those existing agreements or those existing relationships that you have to ensure that they're going to be basically they're still in line with what the market would require, that they're actually what they're charging you is consistent with what the contract would outline. And then finally, are they delivering on the services that are promised in the contract? Are they fulfilling all of their obligations? And if not, can you compel them to do something about that? Can you get them to do it? Or even two, potentially going out and trying to find a new provider there too. So really, just by way of example here, if an employer has been engaged with the same FSA administrator or COBRA administrator or whatever it might be for going on 10 years now, and the contract price has gone up 3% every year, it might be a good time to say, okay, let's take a look at the market. Let's see if the services that are provided under this contract are consistent with what we could find at other providers. Is this a reasonable price given what the market has available? We haven't really looked at this in a long time. So those are just the kind of steps that would be important to make sure that, hey, we're making a prudent decision here. We're thinking through what needs to be done. All right, another best practice that we want to throw out here is just the approach of forming a benefits committee, and this can really be a powerful tool to meet those fiduciary obligations that we've discussed already. They're really important to help ensure that the due diligence process is going smoothly and that you're actually performing that function. And then it also helps to avoid any bias or personal conflicts that might occur on an individual basis as well. One thing that I always like to talk through about benefits committees, I should say, is that it does put a little bit more strain on the HR department because those individuals are really going to be the most up to date in understanding of the process of going through employee benefits and whether that's purchasing or monitoring or whatever it might be. So not only are HR professionals usually required or asked to join that committee, but they're also required to almost educate the other members of that committee as well, because they're far less familiar with employee benefits. That's not a big part of their day job, if you will. So it does put a little bit more strain on the HR department to have a benefits committee. But again, just kind of doing a pros and cons comparison and make sure that it's the right move. Another important aspect is the fiduciary liability insurance. I talked about that before as well. Just making sure that all the members of that committee are both aware of what their fiduciary obligations are, and then as a group procuring fiduciary liability insurance to make sure that everyone's kind of protected in the event that there is an allegation of a breach. Finally, I'd say like the biggest advantage to me, at least from my perspective, is that we talk about due diligence, and if I'm just one person, I'm making these decisions, and I just say, yeah, I took a look and it made the most sense. Okay, that's one thing. But if you have a benefits committee where there's a conversation happening, you have meetings and you have those meeting minutes, and it's kind of a forcing mechanism to document. Pretty much every decision what was discussed, what was the decision made, how did you come to that decision? Those meeting minutes can really be helpful in the event that there are any allegations of a breach, to kind of show this was what our process was, and then show that there was a prudent methodology that was put into that as well. So really, at the end of the day, it might not be the right solution for every single employer. It'll definitely depend on the size of the employer and the personnel that might be involved as well. But it can certainly be a strategy that can help bolster a plan sponsor's adherence to those fiduciary obligations overall. So with that, I'll throw it over to Sonia Gordon to talk to us about transparency and reporting.
Thank you, Kevin. Hello, everyone. My name is Sonia Gordon, and I'm going to talk through, again, transparency and reporting laws that are currently in effect and may be up for discussion or enhancement. So transparency rules have become more into the forefront of the regulatory landscape in recent years, where the transparency rules came out as part of the No Surprises Act and originated from an executive order issued in President Trump's first administration in 2019. Now, the purpose of the No Surprises Act and these rules were to, of course, increase transparency in healthcare, mostly in pricing, mostly in surprise bills, in information that is readily available to participants, for example. One big one is air ambulance rules and reporting. Those rules would have required billing disclosures and reporting on air ambulance fees and amounts charged in network and out of network. Those reporting requirements will be needed eventually, but the final rules remain sort of up in the air. Another area that was implemented through the transparency rules were requiring groups and carriers to put cost comparison tools into place, allowing participants to be able to see different costs of different services rendered. Those tools have been implemented and are available from various carriers and third-party administrators, but what we're seeing is that they still need a bit of work, kind of like with any new application or web page. The beta version would be very helpful right now. A lot of them can be challenging to use. They might not have all of the pricing information that one is looking for, and the overall user experience is not what it could be. So those are areas that is sort of a work in progress, you could say, among the different carriers and parties that are working on it and required to cover them. One big area of reporting that is also required under the transparency rules is the gag clause attestation, which requires plans and groups to attest that they have not entered into contracts that impose gag clauses on disclosure of certain information. Uh, Recently, an FAQ number 69 came out enhancing the gag clause attestation rules and requiring the elimination of additional areas where gag clauses cannot be imposed, namely audits per year. The limit on those audits is reduced. The number of records that are audited are also reduced, where the records that can be reviewed and who those results can be shared with on the gag clause that would be reported. Main takeaways on that would be noting that self-insured and level funded plans would want to review their service agreemements and see if there's any amendment needed to their agreement to remove any gag clauses that are now present under this new FAQ, because this is enhanced detail with regard to where a gag clause could apply. The other thing to keep in mind with this one is that vendors are not mandated to remove these clauses. It's the group or the plan itself that is required to report on whether they have a gag clause. So if a vendor does not remove one, especially under the terms of the FAQ, the employer will not be able to attest that they have no gag clauses. They will have to attest otherwise. So that is something to bear in mind. At this point, though, the important thing is to ensure that current agreements do meet with the requirements of this new FAQ. Next slide, please. So in summary, the ongoing transparency rules that have been in effect, and as far as we know are still in effect, are machine readable files, RxDC reporting, and again, the gag clause attestation. With machine readable files, groups and plans are required to post such files containing in-network and out-of-network costs and claims on an external website that can be accessible by participants without any login information or passwords, anything like that. Now, with all of these requirements, these could be completed by a third party, depending on the kind of plan you have in place. If it's fully insured, the carrier would be taking care of this function. But if it's self-insured, you would want to see if your third-party administrator or PBM would be posting these files on behalf of the plan sponsor. But if not, the plan sponsor might need to do it themselves. This is an ongoing requirement, and basically just need to make sure the files are accessible from the employer's website or linked to where the files would be posted by the carrier or the third-party administrator. RxDC reporting. Here, this is another requirement that came about just a few years ago, where plans are required to report certain data related to their prescription drug spending and their overall plan expenses. This one, compared to the others, is a big data gathering project. So this is the one to pay the most attention to in terms of what kind of information a group needs to provide. Again, the carrier may be completing it on your behalf, but the carriers may be sending out surveys to the group requesting certain group information that the carrier is not going to have on hand. Similar for a TPA and PBM, they may not need as much information per se, but the group would want to ensure that the third-party administrator is going to report all the required data on behalf of the plan, and the plan doesn't have to fill in any gaps in the interim. Now that reporting is due June 1st of every year for the prior calendar year, and that is an ongoing reporting requirement, at least at this point. And again, with the gag clause, it's a similar function where a group or the plan is simply going online and attesting as to whether agreements contain any gag clauses. Again, it could be taken care of by the same parties. This one is due at the end of the year, December 31st, and thereafter for the previous for the year that had just transpired. So on December 31st, 2025, the group would be attesting for 2025 and possibly previous years if they had not previously attested, though ideally they have. And with both the prescription drug reporting and the gag clause, both of these reporting requirements would be completed through the HIOS platform on the Center for Medicare and Medicaid Services website. So those are things to keep in mind with the different transparency reporting requirements. Next slide, please. And Why is this so important? Partly because there are ongoing requirements, even though they're not that new anymore, but also because transparency remains a hot button issue with both parties. There are several different bills in Congress and the Senate addressing different ways to create more transparency in healthcare disclosures, lower costs, other sorts of issues around pricing and disclosures. So these are areas where we will stay on top of any additional regulations that are passed and come out and affect your groups. Thank you. And with that, I will hand it over to Russ to talk about ACA reporting.
Thank you, Sonia. You're always so informative. So I am here to talk about the Affordable Care Act. It has been in place for nearly a decade now. But with every law, it seems that there continue to be changes. There are yearly changes in such things as the penalty amounts associated with the ACA and the affordability. And just recently, there were some major changes with respect to reporting requirements by the employers. People are always expecting some changes under a new administration. We do expect some. Back in 2017, the first Trump administration, there was an effort to dismantle ACA, and eventually that did not occur. So I think any changes might be around the edges. But I will say that President Trump in his first term was very active with respect to health insurance. He introduced two new programs. First, the association health plans, which has not gained much traction. But the second change was the introduction of the individual coverage HRA, which we have seen over the last 4 to 5 years really growing in popularity among employers. The major change with respect to reporting, I'll get to in a minute or two, but as I said, it will be a big change for employers. Next slide, please, Kevin. So the first thing that I'm going to want to talk about are the ACA affordability percentages. So the major requirement of the law is that the employer provide a plan that is indeed affordable. And what is affordable? What is affordable is indexed each and every year. And I just thought it'd be interesting to see how the IRS indexes it. So in general, they adjust the percentage to reflect the excess of the rate of premium growth for the preceding calendar year over the rate of income growth for the preceding calendar year. So I thought it would be much more complicated than that, but it's really not. So the ACA allows employer to use three different safe harbors to determine whether a plan is affordable or not. And as you can see, we have the rate of pay, the federal poverty level, and the W-2 safe harbor. So for plans that begin in 2025, the affordability safe harbor will be 9.02% of the single only plan contribution by the employee. Now, this is in contrast to the plans, the safe harbor affordability for plans that came about in 2024. So if you have a non-calendar year plan that began July 1st of 2024, you would have used the 8.39% affordability percentage. And if you have a calendar year plan that began January 1st, you would be using the 9.02% affordability percentage. So the three of us have been involved with the ACA now for quite some time. I think we would all agree that the overwhelming majority of at least the clients that I work with for Hub use the rate of pay. The rate of pay calculation is done before the beginning of the plan year. So you kind of set your bet before the plan year begins. The W-2 safe harbor is a look back. So less of our clients use that. And then in my experience, less employers use the federal poverty level to determine the affordability. So we're going to move on to the next slide. So just some reminders. So the affordability is based on the single only tier of coverage. Some people refer to it as the employee only tier of coverage. And it's based on the lowest cost plan offered to the employee, not necessarily the plan the employee chooses. You need to keep that in mind. Only one of the safe harbors need to be satisfied for the plan to be affordable. And the rate of safe harbor is the rate of pay safe harbor is always based on 130 hours, regardless of how many hours worked in a specific month. I do know that sometimes this gets very confusing for employers when they are trying to determine the affordability of their plan. And as I mentioned earlier, the W-2 safe harbor is kind of a retroactive look back based upon the employee's W-2 for the preceding year. And lower rates for participating in wellness plans cannot be considered with respect to the cost or for the affordability of the plan. So if I can go to the next slide, please. So ACA reporting. So many people on this call have been doing ACA reporting for quite some time now. Just some things to remember, so that employers with MEC coverage and with ICRAs are also responsible for reporting their coverage. All applicable large employers, those employers with 50 or more full-time equivalent employees are required to report as well. I think we're all familiar with the phrase 1095s and 1094s and the distribution of the 1095C requirements to employees in the filing of the 1094Cs with the IRS. So we're going to talk a little bit more of that with the next slide. So the biggest thing to remember here is a recent piece of legislation signed by President Biden between Christmas and New Year of calendar year 2024. And it indicates that starting in 2025 for calendar year 2024 reporting, the employer is only required to provide employees with a copy of the 1095C upon request. There is an obligation that the employer provide notice of that they will be providing the 1095C upon request, because it is a change. Because as you know, it needed to either be mailed or hand delivered, etc. And this is a different way of providing these 1095s to the employees. Once that notice is given and an employee does request a copy of the 1095C, the employer has a 30-day window in which to be able to provide that to their employees. And you can see what the deadlines are now, that if you're filing with your IRS, your forms that are required, you have until March 31st of 2025 for forms that will be filed electronically. And for any forms that are going to be filed with the IRS in paper, you only have until February 28th of 2025. But a change that occurred a couple years ago, it requires that any employer that files 10 or more returns, including the W-2s, they need to be required electronically. So that really reduces the amount of paper that the IRS will be receiving. And one thing that I just specifically want to mention, and we'll get into more detail in the next slide, is that the states now have gotten involved in wanting to receive information about employers and employees' health insurance coverage. And you can see that California and Massachusetts have the earliest deadlines, and those were due on January 31st in 2025. Kevin mentioned earlier that I am from Massachusetts, and Massachusetts has its own form. It's called a 1099-HC, and the other states really are allowing individuals and employers to use the 1095Cs as evidence of coverage being provided by the employer and coverage having been received by the employee. So Kevin, can we go to the next slide, please? So here's more on each state individual mandate. I specifically talked about California and Massachusetts, but we see the states primarily on the East Coast, New Jersey and Rhode Island and Washington, D.C., having their own reporting requirements. I think the reason that these came into play, usually right around calendar year 20 and 21, was because there was a movement that passed, or excuse me, a law that passed in 2019 that required individuals to no longer have to provide their 1095-C on their federal income tax. And I think the employers or the states referenced in this slide wanted to maintain notice of availability. So we'll go to the next slide. And I think the least favorite topic for most employers regarding the ACA is what happens when you fail to distribute the 1095-Cs in a timely manner, or what happens if you make mistakes. So I will say one thing that we are keeping a close eye on is during the first Trump administration, the IRS provided what was referred to as a good faith effort rule. So if an employer could prove that they made a good faith effort to distribute the forms on time or to file forms that were indeed correct and did not have any bad information on it, then there would not be an assessment of a penalty. However, with the change of administration, the IRS began assessing penalties for failure to distribute the forms on time or where mistakes were made on the 1095-Cs and the 1094-Cs. And you can see that there was provided an opportunity for the employer to reduce the potential penalty if they corrected that within 30 days of their initial distribution or filing. And then there was an ability to reduce that if you corrected that by August 1st, and then again August 1st or later. And then there was a very large fine if the employer intentionally disregarded the ACA filing requirements. In the years that this has been in place, I personally have not seen a penalty where an employer has intentionally disregarded the ACA filing requirements. I think we are far enough along into the legislation that employers know what their obligations are, and many payroll providers who are doing the reporting on behalf of employers have kind of got this all figured out. So it's we don't see many of these penalties now. Next slide, please. And as I continue to be the bearer of bad news with respect to ACA penalties, you can see how the penalty amounts have changed from 2020 through 2025. So the penalty amounts are actually indexed each and every year. And it's really based upon reporting for national health expenditure accounts, where income and premium data are put together and the IRS issues what are potential new penalties each and every year for violations of the employer share responsibility provisions. And just as a recap, there are two major penalties associated with the ACA. The first is, as you can see, 4980H-A, and that is where the employer fails to make an offer of coverage to at least 95% of their full-time benefit eligible individuals. There is a penalty for all employees of the employer minus the first 30, and it'll be $2,900 per employee in 2025. We see very few of these penalties now. It was a lot of the penalties that we saw on the Form 226J letter from the IRS really were just reporting errors between the employer and the payroll vendor company that was doing the reporting. The second penalty, which we see much more often, is what's referred to as the B penalty. And this is where if an employer provides a plan that is not affordable using the safe harbors that I talked about a few slides earlier. So these penalties are assessed when an employee of yours goes to an exchange and receives a premium tax credit, and the employer will end up receiving a penalty letter through the 226J with the IRS. And normally the IRS is about 2 years behind in enforcing these B penalties. So if we could go to the next slide. So a couple things to remember with respect to enforcement. So as I just mentioned, the IRS is currently enforcing 2022 mandates now. The IRS has been increasing the focus on the penalty enforcements, specifically throughout the Biden administration. And one thing we will keep close eye on is to see whether the Trump administration will do that. But there is a reason for heightened enforcement. It is with respect to the amount of money that can be gained by the federal government for major enforcement. So the amount that has been collected or that had been assessed versus the amount that has been collected, there's a great disparity there. So enforcement for the ESRP, employer share responsibility, will be something that we will really kind of keep a close eye on. And with that, I'm going to return it to Kevin.
All right. Thank you very much, Russell. Okay, so the next section we have here is other benefit updates. So we've compiled a number of significant benefit updates to be mindful of in 2025 and provide some high-level, hopefully helpful information on a few of them. All right, so first up, we have mental health parity. The final MHP rules were released back in September of last year. Mental health parity, not necessarily a brand new concept, but we did get final rules back in September. Generally speaking, the mental health parity requirements would just say if a plan does offer mental health and substance use disorder benefits, they have to offer those benefits in parity with medical and surgical benefits. So I like to think of it as like a balancing scale on each side. Ideally, you'd have kind of an equal weight to both of them. But really, at the end of the day, you just can't have more restrictive standards. You can't make it more costly to access mental health benefits and substance use disorder benefits when compared against medical surgical benefits. So really, at the end of the day, the updates are designed to strengthen mental health parity and eliminate some of the existing loopholes. And essentially, the goal of the initial legislation and the rules is just to ensure that those benefits, mental health and substance use disorder benefits, are treated the same as those medical and surgical benefits at the end of the day. So the new rules take effect in phases. So most provisions will apply to plans renewing on or after January 1st of 2025, so this year. However, some key components will not take effect until the first plan year beginning on or after 2026. So really, like the phased approach gives plans a little bit more time to align with the new requirements, and will still obviously ensure that there's stronger protections in place at the end of the day. So we'll start with just the rules that are beginning on or after the first of this year. So first, state and local governments will no longer be allowed to opt out. So again, this is all going towards broader protections for more participants. If there's less and less ability to opt out by whether that's a state and local government or small employers, whatever that might be, more participants are going to fall into that bucket to be to have that strong mental health and substance use disorder coverage. Additionally, those new rules will also reinforce that you cannot have greater restrictions on those benefits compared against medical and surgical benefits. And this is especially true or critical for non-quantitative treatment limitations. And we'll talk through that a little bit more when we get to the comparative analysis. But essentially, parity or restrictions on benefits can come in a lot of different ways, mainly quantitative treatment limitations or non-quantitative treatment limitations. Looking at those, a quantitative, it's tied to a number. So is there a dollar limit, a visit limit associated with the benefit? Non-quantitative treatment limitations don't have any number attached to them. So looking at prior authorization requirements, looking at medical management techniques in general, step therapy. So those kind of things that aren't necessarily associated with a number, but can still be restrictions on access to that benefit or service, right? And then a few other changes that are going to occur in 2026 and beyond. First of all, we have the meaningful benefit standard. So essentially, this is designed to ensure that mental health and substance use disorder coverage actually provides like meaningful value to participants. So that'll be important in 2026 and beyond. Next, we've got the prohibition on the use of any discriminatory factors and evidentiary standards that would create any unnecessary barriers to care. Additionally, we've got the required use of outcomes data to measure the effectiveness. And then finally, we've also have, like, as a very important topic, which we're going to talk about on the next slide, just the strengthened comparative analysis requirements as well. So talking about the comparative analysis, there are a few new requirements, but this is another aspect of the law that's not necessarily new. The comparative analysis is meant to be a side-by-side comparison of the mental health and substance use disorder benefits compared against the medical and surgical benefits, and looking at those non-quantitative treatment limitations and making sure that there's parity between them, or that there's not at least more restrictive standards put on those non-quantitative treatment limitations. So again, not new. The comparative analysis requirement has been around for a few years, but just given the new rules, there's been, obviously it's now codified or put into those regulations where we see exactly what those requirements are going to be. One interesting thing, and it kind of circles back to my discussion on fiduciary duties earlier, is that the new rules actually require that a plan fiduciary certifies that the fiduciary engaged in a prudent process to select a qualified service provider, and that they to actually create and document the comparative analysis, but then also monitor that service provider as well. So we're talking about the selection of the vendor and then the monitoring of that vendor as well. So having a requirement to actually have a fiduciary sign off is interesting, and it's something that is new, at least for this year coming up. So when considering the comparative analysis and what needs to be done, it's like, what are the action items, what do plan sponsors need to do? I think first and foremost, just doing a review of these new rules with your carriers or third-party administrators for any 2025 plan renewals. What do we need to do? Anything? Do we need to change anything to make sure we're in line with these rules? Obviously, you'd want the answer to that to be no. We're all set. We've already looked at it. We've made the changes that we need to. So definitely an important conversation to have. Again, as I just mentioned, for plans subject to ERISA, there's now the fiduciary requirement. So ensuring that if you are engaging a qualified service provider to perform the service, that you're ready to make that certification as to their ability to do that. And then finally, just ensuring overall, I know we're talking about these kind of like step things that need to be done, but really at the end of the day, the idea is that broader protections for broader participants. So taking a look at your plan design, making sure that the benefits that are available, potential exclusions that might be out there, just making sure that they are aligned with both just mental parity in general, and then making any required updates to ensure that these new parity standards can be implemented on the plan. So with that, I'll throw it back to Sonia. So take it away.
Thank you, Kevin. I'm going to go over some of the preventive care developments. In recent years, there have been some lawsuits addressing the preventive care requirement under the ACA, namely lawsuits that are wanting to go against the requirements to cover coverage of PrEP, the HIV prevention drug in their group health plans, as it violates their religious rights under the Freedom of Religion Act. And essentially, with this case, the Fifth Circuit has ruled that only the plaintiffs who were particularly who were bringing the litigation, they were granted relief from needing to follow these directions, and they're relief and dismissed from the national injunction issued by the lower court. So that would still require that all other employers continue to provide and pay for the existing preventive care services that are required at no cost. But these plaintiffs who brought suit are exempt from paying for PrEP. This decision has been appealed to the Supreme Court. There to hear arguments on this particular case, Braidwood, and they will be rendering a decision, I believe, this summer sometime, I think, yes, June 2025. Another area of development in the preventive care rules under the ACA would be that there's the ACA FAQ 68, which is requiring plans to cover oral and injectable formulations for PrEP, possibly in response to this litigation. So with this FAQ, it included coding instructions for those items and also clarifying breast reconstruction requirements that would be present under the Women's Health and Cancer Rights Act. The HHS also rescinded its bid to require non-grandfathered plans to cover over-the-counter contraceptives. That was rescinded towards the end of last year, and so that is an area that is no longer a possible addition to the preventive care requirements, at least as of now. Next slide, please. Also, there are new HIPAA privacy regulations that went into effect at the end of last year. On April 2024, HHS issued updated HIPAA regulations that were imposing new restrictions on when information can be disclosed to a third party about individuals who may have sought or were provided related to services related to health reproductive services, and that includes abortion, but could be other services, including other sort of reproductive health visits, birth control, and the like. So these updates were put into place mostly in response to the SCOTUS ruling overturning Roe v. Wade. This would grant the states the authority to regulate abortions on their own, but it's basically saying that the federal government retains the right to decide what of this information can be disclosed, whether abortion is considered legal or not. This way, the information being disclosed to third parties would have to be performed in a state where it is lawful. The rules also establish the use of an attestation prior to disclosing this information to a third party and requires groups to have a new HIPAA privacy notice distributed to participants no later than February 16th, 2026. So there is a little bit of breathing room until that requirement. The new HIPAA regulations also extend civil and criminal penalties for the violation of these new healthcare rights. Next slide, please. And again, just as a reference, these rules apply to all HIPAA-covered entities and business associates, all group health plans, self-insured, level-funded, and fully insured that would have access to PHI, and would also apply to plans, pharmacy plans, FSAs, HRAs, and any others that would reimburse or pay for reproductive services. And as a reminder, the rules went into effect last June. Plans become subject to the new rules as of December 23rd and must update their policies and procedures, implement their new attestation requirements, and update their business associate agreements to include these new protections. And also, of course, as with other HIPAA training requirements, they would need to train staff on these updated internal procedures to align with the new rules. And of course, the new notice would not be in effect until next February. Next slide, please. The other area of HIPAA regulation that is going into effect next February would be the confidentiality of substance use disorder records. Similar to the reproductive health information, it's requiring a consent or attestation for disclosure of such information, where a single consent for any future use and disclosure of treatment, payment, and healthcare operations relating to substance use disorder must be signed. It'll allow these entities and associates that receive these records under the consent to redisclose in accordance with any permitted uses under HIPAA. It would also permit the disclosures without consent for the normal functions related to public health, providing that they're disclosed and, of course, de-identified according to HIPAA standards under the privacy rule. And it would also restrict the use of these records in testimony in any court proceedings, civil, criminal, administrative, legislative, and the like. And as with the reproductive health rule, this rule also increases penalties, where it's imposing Part 2 penalties imposed by HIPAA by replacing criminal penalties only that are currently in place with civil and criminal enforcement authority that would apply to other HIPAA violations. Next slide, please. And I will turn it back to Russ to talk over our shifting regulatory landscape.
Thank you, Sonia. So I get the pleasure of talking a little bit about the last federal election. And the reason we're talking about this because much of what we have spoken about regarding compliance is a result of legislation in Washington. And yes, we had an election, and yes, there was a majority of Republicans in the House and majority of Republicans in the Senate. However, both of those uh, were very narrow margins. And so trying to make big changes in legislation is difficult with very narrow margins. So we will be on the lookout for some potential changes, but how significant, it's a little too soon to tell. So we do know that right along party lines, the Republicans have indicated that one of their immediate priorities is the extension of the Tax Cuts and Jobs Act before the provisions expire on December 31st. If you want a much deeper dive into the election's impact on employee benefits and employment law, please sure to check out Hub's recent on-demand webinar, titled Post-Election Compliance Perspective. We'll include a link to that on our webinar replay page. But a couple of things, Kevin, if you could go to the next slide, that really need some attention on your part is the sunsetting of the telehealth and high deductible health plan requirements that came into play during COVID. Those provisions are sunsetting or did sunset on December 31st, 2024, which now means that high deductible health plans must charge a fair market value for telehealth services as of January 1st of this year, 2025. There does appear to be a bipartisan move to extend that sunsetting or kind of bring it back to life, but we don't see it as yet a priority in Congress, but it is something that we're paying very close attention to. And the other thing is there were substantial changes to Medicare in late 2024. One of them involved in how to determine whether the employer plan either met or exceeded the requirements under Medicare Part D. As we all know, there is a requirement for the employer to send out a notice to specifically those employees over age 65 that are eligible for Medicare, indicating whether the plan is indeed credible or not. So you could use various methods to make that determination. And this determination method, which the Centers for Medicare Studies wanted to implement, appears to be part of these Trump executive orders putting certain things in limbo. So as of right now, there is no clear direction from the federal government on how this should be done. It's another thing that Hub will pay very close attention to. And on the next slide, I'm going to talk about the future of ACA subsidies. So in these subsidies, which enabled more individuals to qualify for subsidies and increasing the subsidy amount for each individual on plans, was extended through 2025. It is the goal of the Republicans to allow that to sunset, but still, we'll wait and kind of pay attention to this. And so what it does, it weakens the exchanges by making them less affordable for individuals. And the savings could potentially be used to extending the Tax Cuts and Job Act, which I indicated just a minute ago is a priority of the Republicans. This is important for employers to pay attention to because you have to look to see what is the potential impact on employers if employees who are going to the exchange, it is more expensive for them or it's more difficult. And is there then going to be an impact on employers as a result of that? And I'm now going to turn this back to Sonia.
Thank you, Russ. One similar development to what Russ mentioned is the tax exclusion of employer-provided benefits. The code allows employer benefits, especially amounts through health insurance, to be tax-free at pre-tax to the employee and can be deducted by the employer. But there's support within the House to cap or even eliminate these exclusions. And as Russ was stating before, these these amounts, by taxing the amounts that are paid as part of regular income, would also be used to pay for extending the Tax Cuts and Jobs Act. Now, this would expand the tax base and result in tax increases for employers, but this is going to also significantly increase cost for the cost of benefits and the deductions that participants will need to make. So, will this change if it passes? Would the expanding tax base be offset by rate cuts? I don't know that I've seen a rate cut in a very long time. And how will this impact enrollment in employer plans? Enrollment could well go down, but if exchange rates are also high as a result, it may be a tough call as to where healthcare will suffer in which direction, if at all. So this would be an interesting one that is very important concern to many plans, as it will, change their bottom line, and we will keep an eye on this area as well. Next slide, please. And with reproductive rights, just as reference to what we were talking about before, since Dobbs, many states have taken steps to either significantly restrict access or increase or entrench their right to access of abortion and reproductive health in their state constitutions. This is consistent with Trump's approach of saying that he wants to leave the decision to the states. But for now, bear in mind that as of right now, fully insured plans that are subject to state insurance laws would need to follow the laws of that state, and it may differ from state to state if you're a multi-state employer. And self-insured plans would still be governed by ERISA alone, but state laws would still need to be used to determine access to abortion. And with that, I will hand it back to Kevin.
All right. So I want to just be mindful of time here. I know I only have a couple of minutes left. Essentially, Loper Bright and Corner Post taken together can have a pretty significant impact potentially on agency power, I guess the shifting power between maybe the courts and an agency as well. So starting with Loper Bright, the law of the land for the last 40 years has been the Chevron doctrine, which essentially requires courts to give deference to any federal agency's reasonable interpretation of ambiguous laws. So when Congress enacts a statute or a law, then an agency issues regulations interpreting what those laws mean. At the end of the day, courts have to, before Loper Bright, courts had to rely on those regulations in terms of what the law said and resolve those ambiguities. So what Loper Bright does is it actually gives the interpretive authority of ambiguous laws back to the courts. So now rather than having one law of the land being those agency regulations, courts will now be able to interpret those kind of independently, right? So that could definitely lead to some confusion across different circuits if there's different rulings in different courts. So if court in the Fifth Circuit says that a law means X and the Seventh Circuit says it means Y, then there's going to be a circuit split and could cause some confusion, especially make it difficult for employers and anybody really trying to comply with that law. And then quickly with Corner Post, basically before Corner Post the case, there was a 6-year statute of limitations for challenging any agency rules under the APA. And what that was generally interpreted to mean was whenever the agency issued a rule, there was a 6-year time period where there was a statute of limitations in place. But now, after the Corner Post decision, that 6-year statute of limitations doesn't begin to run until a party is first harmed by it. So if I create a business or something and an agency ruling actually impacts my business in a harmful way, now I have basically I have 6 years to bring suit. Basically, that just takes it from that first 6-year period to any time a new business or a new entity is created that could be harmed by that rule. It effectively makes that the exposure in perpetuity, essentially, right? So it's really going to have a major impact on agency power at the end of the day. Important to note that this doesn't mean that all regulations are now null and void. They don't exist. They're not going to be important. It just means that courts can now interpret ambiguous laws in any way that they want based on what the rules say. They don't have to necessarily just defer to agency action. So really, taken together, it could just face more legal challenges. There will be more regulatory uncertainty and potentially even a slowdown in rulemaking as they try to get their, make sure that they're shored up on everything before they go in and then issue a rule. So that's a pretty quick and high-level overview on Loper Bright, but hopefully found it helpful here. So it looks like we're not going to have time for questions and comments, but if you did submit them, rest assured that we'll pass along that question, we'll pass along your information to a hub representative, and they will reach out with more information. So on behalf of Hub International, thank you so much for joining today's webinar. We hope that you found the information useful as we enter into 2025. As a reminder, a link to the recording as well as a copy of the materials will be sent to everybody registered for the event, as well as continuing education credits will also be found there as well. Again, we ask that you take a minute to fill out the survey before closing out your browser. This feedback is super helpful to us as we plan out our future webinars and events. So this will conclude our broadcast. Just want to take a time to thank you, Russell. Thanks, Sonia, and thanks everybody that attended. We hope everyone has a great rest of their day. Thanks so much.
Thank you.